Hi, I'm Greg Dell with Dell Disability Lawyers here with Alexander Palamara, and this is our weekly series of frequently asked questions. And this week we're talking about questions about Prudential disability appeals. And Alex, we're going to go through a couple questions today, and we certainly encourage people to ask us these questions, which they can submit on our website, or certainly call any of us at any time for a free consultation to discuss their claims. So the first question for Prudential today is, what are a claimant's chances of winning a Prudential disability appeal?
Well, we like to think that if you hire us, the chances are great. You know, every case is dependent upon facts, though. You can't just claim disability, say, I'm disabled, pay me benefits. You have to be able to prove your case. And the way you prove your case is with proof. And what is proof? Medical documentation, medical evidence, maybe medical records, maybe support from your treating providers, maybe objective medical evidence, testing and whatnot, MRIs, CAT scans, functional capacity evaluations, neuropsych examinations or evaluations. So your claim is only as good as your proof. So in order to put your case in the best light possible with the best chance of being successful either with an application or with an appeal is getting as much proof as possible to show that you're unable to perform either the duties of your own occupation or the duties of any gainful occupation.
You get called all the time. You know, you evaluate thousands of claims every year, and you can only handle obviously so many, but over your career you've handled thousands of these. With regard to Prudential as compared to other disability companies, what percentage of the time would you say you win your appeals?
I like to say I win 100% of the appeals, but it's impossible. I'm dealing with an insurance company. Insurance companies love to take premiums, hate to pay benefits, right? They lose money that way. They're multi-billion-dollar companies because they deny claims and they accept premiums.
Right.
There's no way, no law firm, no lawyer could ever say I'm 100% successful on any of the appeals that I file because it's impossible. Anyone that's telling you that is lying. I'm well over 50% for sure. I'm somewhere between, if I had to guess, somewhere between 60 and 75%. Of course, the thing you have to take into account is I take a lot of these cases sight unseen. All I do is review the denial letters because I take the cases on quick. I review the denial letters. I think there's an angle here that I can win this case. And I take the case on quick because these people have no money coming in and they need the appeal out as quickly as possible. So if I went ahead and said, let me do some more research into your case before I decide to take it on, it can be 30 to 45 days before I get any medical records, and then I can't tell them then, no, I'm not going to take on your case now. Good luck to you, because they only have 180 days to file their appeal,
Right.
and then I have no income coming in. So I take cases almost sight unseen based on what the person's telling me, and sometimes the cases turn out to be a lot weaker than the person described, and I still do my best on those appeals, but maybe that hurts my percentage a little bit, But for the most part, I make sure that I put my client's claim in the best light possible when I file that appeal, because it's so important, because it gives the client a chance to either get on claim or get back on claim, or you're setting up their case for a lawsuit, and you need your file as strong as possible for a potential lawsuit.
Okay, so you have a very good chance of winning an appeal if it's done appropriately. Now, another popular question we get is, how long is this process going to take from beginning in terms of preparing an appeal through the complete submission of the appeal?
Like, I have people calling me and they want the appeal filed tomorrow, but you just cannot do that. Again, your appeal is your last chance to prove to the insurance company that you're disabled, to reinstate your claim or instate your claim, and it's your last chance to strengthen your file for a potential lawsuit, because if they deny your appeal, your claim file is closed, and the claim file is the document that's going to go in front of the judge. And once they issue a final denial letter of your appeal, the claim file closes. So if there's any medical records that you did not submit that's not in your record, the judge will never see it. So that could weaken your lawsuit. So you cannot just throw together an appeal. And I understand that these people, the potential clients, want their appeals filed as quickly as possible because they have no income coming in. They're between a rock and a hard place. But it takes time to properly do an appeal, because there's a bunch of groundwork you have to do first, which is including getting a copy of the claim file from the insurance company. You have to request it. They have up to 30 days to provide it to you. Getting updated medical records from all the treating providers, reviewing those records, reviewing the claim file once you get it, getting additional testing done, reaching out to the treating providers to drum up more support for the claim. And there's a lot of wheels in motion, a lot of variables at play here. We don't just sit on appeals and say, let's just wait the 180 days. We're actively working on these cases, and we want to get them out as quickly as possible because we want our clients back on claim as quickly as possible. But it does take a little bit of time. I know the next question is, what's the average time period? Every case is a little bit different. Some cases I can get an appeal out in 30 to 45 days if everything just comes together. Sometimes it takes the whole 180 days. There's just so many variables that every case is a little bit different. I like to get them out within 90 days, because that gives me enough time to get the medical records, and I should have enough time to put everything together. But sometimes it takes longer, sometimes it's shorter.
And then once you submit an appeal, how long does Prudential usually take to make a decision?
So under these group disability insurance policies that are governed by ERISA, they have 45 days to give an answer on an appeal. However, the laws give them, they can take one extension of an additional 45 days if they have good cause. So technically they have 90 days, and more often than not, we see them going beyond the initial 45 days for whatever reason. So I would expect once we file the appeal, on average, it probably takes about 60 days, maybe sometimes 75 days to get an answer on the appeal. Sometimes they go the full 90 days. If they go a lot longer beyond the 90 days, I'm ready to file a lawsuit though. But typically it's about 60 to 75 days before we get an answer. Sometimes it's quick. Sometimes our appeals are that strong, the evidence is so overwhelming that they literally take 3 weeks.
Right.
I've never had less than a week yet, but sometimes it's pretty short.
All right, the other thing that we like for people to understand and commonly asked is what's going on at Prudential once they receive the appeal?
I don't 100% know. I've never worked there yet. However, what they typically do is this. So once you file the appeal specialist, a person gets assigned the appeal, someone that had apparently nothing to do with the initial decision at the lower level. So this appeal specialist just reviews appeals all day, every day. So they get the appeal, they get all the documentation we submit with the appeal, and I guess they take those medical records and they find the appropriate specialist. Sometimes they use an in-house nurse, sometimes they use an in-house doctor. Sometimes they go out and find what they call an independent physician consultant, where they use an outside doctor to perform a medical record review of the paper records. Sometimes they send our clients to independent medical examiners, like have an examination in person. So these appeal specialists get all the files and assign it to the various people. Sometimes, I mean, I like to think they should assign it to a doctor or physician of the appropriate specialty. So if you have a back issue, maybe an ortho, sometimes sending it to a neurologist, sometimes sending it to whoever type of doctor, the appropriate doctor. More often times they don't. They just use occupational or medicine doctors. They kind of use or a family medicine practitioner. But that's where it leads them down the wrong path a lot of times. So they should use of the appropriate specialist or specialty, and they do not. But that's what they do. They send the records out for review, and then they get these reviews back, and whatever those reviews, the reviews, mind you, that they're paying for, more often than not, to support their decisions to deny the claim, they just willy-nilly follow that opinion of that doctor and deny the claims and lead them down the wrong path.
And who's the person at Prudential that ultimately makes the decision whether or not they're going to reverse a disability denial?
Typically it's the appeal specialist, and sometimes their managers involved too. They normally have at least one person sign off on it, if not two. And the second person is really just, I feel like they spend 5 minutes with the claim and they're just denying the claim. But you'll see there some notes in there, like 3 sentences long, agreeing with the appeal specialist's decision to approve or deny the claim. But typically it's the appeal specialist with the ultimate power.
All right. If you win an appeal, will Prudential pay the attorney fees that the client is ultimately responsible for?
Everyone asks that, and I understand why they want to ask it, because it's almost not fair to them, because the insurance company wrongfully denied their claim, or maybe rightfully denied their claim initially, but they came to us for help. And I wish the insurance companies would pay their fees. It seems fair to do so, but they'll only do so. The only time the insurance company will ever pay fees if ordered by a court. And the only time they're ever going to be ordered by a court is if they deny your claim, deny your appeal, and you file your lawsuit and win your lawsuit. The courts have the discretion to award attorney's fees and costs in favor of the prevailing party. So the only time an insurance company is ever going to pay those attorney's fees and costs is if they're ordered to by a judge, and the only way they're going to do that is if you have to file a lawsuit. So unfortunately with appeals, they'll never pay attorney's fees.
And it's not only that they won't, they're not required by law to do so.
They're not required to do so, and they're not the giving tree. They don't give any more money than they have to.
Okay. Most clients who contact our law firm and they've been denied benefits, they obviously don't have any income coming in, and they're not in a position to pay a substantial amount of money to file an appropriate appeal, which it takes a lot of time, especially in the limited number of appeals that we are able to work on and accept. We accept those claims on a contingency fee basis. Can you explain what that is and how it's helpful to have a client be able to afford an excellent attorney?
Definitely. I never charge anybody up front. I never say, pay me $5,000 retainer fee and I'll start working on your case. I know that these potential clients and these are now clients have their backs against the wall. There's no income coming in. I couldn't even imagine my income stopping immediately out of nowhere, mind you. A lot of times they have no idea that denial is coming.
No notice at all.
No notice at all. So there's no way I can charge them money up front. So, and it also gives us great motivation, because we only get paid if we win. So we're doing the best job possible to ensure our clients not only get paid so that we can earn our attorney's fees as well. But it's contingent. It's contingent upon us winning the case. If we don't win the case, they don't pay us $1. And I find that fair and reasonable because there's just no way I could ask them to put it on a credit card and get them further in debt.
Right.
You know, it just wouldn't be fair. So we always work on a contingency fee. Always happy to do so because I want to win their case for them.
Right, and I know we become very vested in these cases because we're basically becoming a partner in their claim, and then it becomes personal not only for them but for us to do every single thing possible to win this claim.
100%. We're investing our man hours and we're investing money into the case as well. We're not just, hoping for the best, throwing medical records at the wall, hoping we win. We're making sure we do it right and the client has the best shot of getting back on claim.
And then some people call and they go, Alex, I just want to file a lawsuit. I don't really want to waste time with this appeal, especially after you've suggested that it can take anywhere from 60, 90 to 180 days. Why, unfortunately, does a claimant have to file an appeal? And what happens if they don't?
Well, the ERISA laws require that they file an appeal. You cannot just file, once you get an initial denial, you cannot just file a lawsuit. If you did, it would just be kicked out of court. You might have to pay their costs and fees for defending it. Because the government, when they passed the ERISA laws, stated that before you can file an appeal, you have to exhaust your administrative remedies. And what are your administrative remedies? It's the appeals process. So if they deny your claim, the first thing Prudential, if Prudential denies your claim, the first thing you have to do is ultimately file an appeal. If they deny your appeal, finally you can file that lawsuit. But you cannot file a lawsuit before then. Now, I know you can say, hey, just file a quick appeal so we can get the lawsuit filed. But you can't do that because if you just file a quick appeal saying, hey, I appeal this decision, they're going to, of course, deny that appeal. But again, as soon as they deny that appeal, the claim file is closed. If your claim file is weak, your lawsuit's weak. You're not going to win that lawsuit. You cannot submit any more documentation with your lawsuit that you did not submit on appeal. So it's important. I know people want to file the lawsuit and just try their hand in court, but the problem is the appeal has to be properly done. And if they deny the appeal, then we're more than happy to file the lawsuit for you. But the appeal has to be properly done with all your documentation submitted before they render a decision on your claim.
And I know we have other videos where we talk about tips for filing a Prudential disappeal, but really one of the best things for people to do is to go ahead and call us, any of our disability lawyers, submit a copy of the denial letter, and we'll immediately be able to review that and let them know immediately whether or not we can assist them.
Definitely.
So many more questions that we could talk about through Prudential, about Prudential, and we have tons of videos and articles and resolved cases, everything there is to know about Prudential. So if you're somebody out there who needs help with either your short-term or long-term Prudential disability claim, feel free to reach out to Alex or myself. No matter where you live in the country, we'll assist you and we'll always provide you with an immediate free phone consultation.